If you own NFA items individually, they become part of your probate estate. That means court involvement, public records, a public inventory of your firearm collection, an executor who may not understand federal gun law, bureaucratic transfer headaches for your family. And if your executor mishandles the transfer, that mistake could become criminal. What if I told you that letting your brother borrow your suppressor for the weekend could technically be a federal felony? Not because you sold it, not because you transferred ownership, not because you were doing anything shady, but simply because you weren't physically present. Sounds ridiculous, right? But under federal law, that simple, well-intentioned act could create what I call an accidental felony. Today, I'm going to explain why this happens, what the legal landmine actually is, and the completely legal strategy that fixes it. It's called a gun trust, and most gun owners either misunderstand it or have never even heard of it. Let's break it down in plain English. Here's the issue. Possession. When you purchase an NFA item, a suppressor, a short-barreled rifle, or other regulated firearm, the ATF paperwork lists you as the legal possessor. Not your spouse, not your adult child, not your hunting buddy, you. And in federal firearms law, possession doesn't just mean physically holding something. There's also something called constructive possession. If your spouse knows the combination to the safe where the suppressor is stored, someone could argue she has access and therefore constructive possession. If you leave your SBR in your brother's truck, it's in his possession. And if he's not legally authorized, that's a felony. We're not talking about a slap on the wrist. We're talking about federal charges, massive fines, potential prison time, all from an honest mistake. Most people buying NFA items never hear about this risk in a clear, practical way, and that's the legal minefield. Now, here's where things get interesting. A gun trust is simply a legal entity that owns the firearm instead of you owning it individually. Think of it like a very small, private, legal container created specifically to hold firearms. Instead of John Smith owning the suppressor, it becomes the John Smith Gun Trust owning that suppressor. You're still in control. You're typically a trustee, but you're no longer the only person legally tied to possession. And here's the key feature. You can name co-trustees. Your spouse, your adult children, your hunting buddies. Once they're legally added as trustees and properly approved under federal law, they can legally possess, transport, and use the NFA items owned by the trust. Now, your brother wants to take the suppressor on a hunting trip without you? If he's a co-trustee, that's legal. No accidental felony, no gray area, no guessing. That's not a loophole in the sense of dodging the law. It's using the law correctly. Now, let's talk about the part most people overlook. What happens when you die? If you own NFA items individually, they become part of your probate estate. That means court involvement, public records, a public inventory of your firearm collection, an executor who may not understand federal gun law, bureaucratic transfer headaches for your family. And if your executor mishandles the transfer, that mistake could become criminal. A properly drafted gun trust and following the rules avoids all of that. Because the trust owns the firearms, not you personally, the trust continues after your death. You name successor trustees ahead of time. When you pass away, control transfers seamlessly. No probate court involvement, no public inventory, no unnecessary exposure, no extra transfer taxes, no confusion. From an estate planning perspective, that's as powerful as a revocable living trust, but providing federal protection as well. It protects privacy, it protects your family, and it protects your collection. Here are a few additional points. First, age. Trustees only need to be 18 years old under federal law. That means responsible adult children can legally possess NFA items owned by the trust, even though they wouldn't yet be old enough to purchase those items from a dealer themselves. That age is usually 21. Now, here is a critical item. A gun trust is not a way to skip background checks. That's outdated information. Since ATF Rule 41F went into effect in 2016, every responsible person on the trust must submit fingerprints, submit photographs, pass the same ATF background check. So the trust isn't about avoiding scrutiny, it's about creating flexibility and structure. It's about shared legal possession, and it's about proper inheritance planning. Can you find gun trust templates online? Yes. Should you? Probably not. If you have never used a rocket launcher before and someone handed you one, would you just pretend you knew what you were doing and see what happens? Or would you want to make sure you were guided through the process by someone who knows what they are doing until you felt comfortable and confident doing it yourself? When it comes to a gun trust, the smart move is to work with an attorney who understands both trust law and firearms regulations, because this isn't about just drafting a document. It's about proper trustee structure, correct language, compliance with federal law and rules, compliance with state law, avoiding unintended consequences. When done properly, the peace of mind alone is worth it. So, in conclusion, a gun trust isn't some shady workaround, it's a legal framework. It protects your spouse, it protects your children, it protects your friends, it prevents accidental felonies, and it ensures your firearm collection passes to the next generation privately and smoothly. That's not gaming the system, that's being a responsible owner. If you found this helpful, check out the other videos we've linked in the description below where you can go deeper into firearms planning and legal strategy. And if you have questions, drop them in the comments. I'll see you in the next video.